ในสาขาวิศวกรรมอาหารจากมหาวิทยาลัยเกษตรศาสตร์และจบการศึกษาวิทยาศาสตร์มหาบัณฑิตในสาขาเทคโนโลยีอาหารจากมหาวิทยาลัยนิวเซาท์เวลส์ประเทศออสเตรเลียค่ะท่านมีความเชี่ยวชาญในด้านการประเมินความเสี่ยงด้านอาหารระบบคุณภาพและความปลอดภัยทางอาหารท่านมีประสบการณ์ในการร่วมจัดทำมาตรฐานสินค้าเกษตรและอาหารแห่งชาติมามากกว่า10 ปีค่ะและร่วมเป็นผู้แทนไทยในการกำหนดมาตรฐานด้านอาหารในระดับภูมิภาคซึ่งเกี่ยวข้องกับความปลอดภัยทางอาหารคุณภาพอาหารและการผลิตอาหารมามากกว่า20 ปีในโอกาสนี้ดิฉันขออนุญาตมอบหน้าที่ผู้ดำเนินรายการให้แก่ท่านพิสารค่ะขอเรียนเชิญค่ะ
ขอเสียงปรบมืออีกครั้งนะครับ
Excellency, distinguished delegates and participants, good morning. สวัสดีครับทุกท่านนะครับ I'm glad to see lots of participants today. According to the registration, I was told that there are more than 200 participants registered today, and more than half of the participants are from industry. So Thai participants are very interested in this food safety seminar today. It is our great pleasure to have 3 experts from EU with us today. 2 of the experts from DG Sanko of the European Commission and 1 from the European Food Safety Authority or EFSA. So this is a very good combination of the speaker today. Today we will have 8 presentations by these 3 experts. 3 in the morning and 5 will be in the afternoon. So I'm sure that we will get the overview as well as the detailed information about the EU standard and regulation framework and also risk assessment according to food safety. And at the end of each half day, there will be question and answer session for half an hour each. So during each presentation, if you have question, you can note your question. You can keep it to the staff, or you can keep it until the question and answer session before lunchtime and before the end of the day. So I will start with the first speaker today, Mr. Patrick de Boisser. He is the Minister of Council of the Delegation of the European Union to Thailand, where he represents the Directorate General of Health and Consumer, or we call it DG Sanko, of the European Commission. And of course, this is his second term in Thailand. He was also in this position in Thailand during 2004 and 2009. So we can say that he is the most well-known EU person by Thai people. So his former position in the European Commission are, for example, advisor to the Director General of DG Sanko, also head of the Food Law and Biotechnology, and head of Pharmaceutical and Cosmetics. Apart from his great experience with European Commission, he also contributes to the academic work by teaching in the area of EU food safety policy and the food law in various universities, for example, in Italy or Belgium, and also writing some books and numerous articles in the area of consumer protection, pharmaceuticals, and food safety. So, ladies and gentlemen, please welcome Mr. Patrick de Boisser.
Sawadee Krap. Your Excellency, Kun Apichat, Mr. Inspector General Kun Niolundom, Kun Pisan, Kun Tritapon, dear colleagues and friends, ladies and gentlemen, it's a pleasure to be here today. And my first words would be to thank the Thai Embassy in Brussels for the gracious invitation and for the opportunity to address you this morning on EU regulations on food and feed safety, current state of affairs, and future trends. Of course, it's not possible to cover all areas of EU food law, even in 45 minutes. I believe it's much more important to give you the general overview and the trend of where we're going, where we have got to and where we are going in terms of food safety. We started legislating on food back in 1962, 50 years ago. And interestingly, the first ever directive adopted by the EU, it was called the EEC at the time, the European Economic Community, was in the sector of food. It was actually a directive on food additives, on coloring matters, in 1962. And because it was the very first directive ever, that colleagues at the time didn't even think of giving it a number. So it's the only EU directive which doesn't have a number. At the time, the only thing that the EU could do was to harmonize national legislation for the purpose of facilitating free movement of goods within the EU. So it was very much about bringing the conditions for goods, in this case food, to circulate within the EU. In 1985, it was felt with the arrival of Jacques Delors at the head of the European Commission that we needed to speed up the work. And Mr. Delors passed the white paper on completing the single market by 1992. You may have heard about this magic date of 1992, which is a bit similar to the date of 2015 within ASEAN for the ASEAN Economic Community or area community. And again, very much the purpose here was the free movement of goods. But in the, and the project was completed by 1992, but in the 90s, the EU was very much plagued by an incredible series of food crises, food scares. And you probably have heard about the most important one, like the mad cow disease or the BSE crisis, which resulted in more than 1 million bovines being slaughtered in the EU to try to get rid of the disease. But there were others, notably the dioxin crisis in Belgium in 1999. And then public concern about issues like hormones and GMOs. The result was very much that at the end of the 90s, European public had lost completely confidence into the regulation of food, the science about food, just about everything. And when Mr. Prodi became the new head of the Commission at the end of 1999 and beginning of 2000, he went to the European Parliament with the program of his Commission, and he said he had 6 priorities. One was the enlargement of the Union, which resulted in 10 new member states joining in 2004. The second was introducing the euro, which again was introduced in 2002, if I remember correctly. Next was employment, which was and still is a key priority. Fourth was innovation and research. I keep forgetting what was the fifth one, but the sixth priority of Mr. Prodi was food safety, restoring a climate of food safety in the EU. And Commissioner Byrne and Commissioner Licknen, which were in charge of food at the time, co-produced the white paper on food safety, which was very much a program, a comprehensive program, to restore confidence in the European public. It was based on the realization that EU food legislation was incomplete, out of date, exceedingly complex, and largely not understood, and that there was a need to provide a predictable regulatory environment for researchers, for producers, for importers, for retailers, and obviously for consumers. The white paper was the most comprehensive program ever in the area of food law in the EU. It provided for the reorganization of the Commission services. DG Sanco was created at the time with merging services from DG Agriculture, DG Industry, and DG Social Affairs. DG Sanco is in charge of health and consumers, including food safety. The Food and Veterinary Office, the FVO, which many of you know because they are inspecting in Thailand, was created. EFSA, European Food Safety Authority, about which you will hear more today, was created also, or was announced. Creation was announced in the white paper. We reformed the regulatory committees. White paper also said we need to reform the way we are consulting stakeholders. So a number of essential structural reforms. There were procedural reforms, changing the procedures in the EU. The rapid alert system existed, but it was given a legal funding, and it was extended to feed, because before that, the rapid alert system only covered food, so it became the RASFF, Rapid Alert System for Food and Feed. And indeed, feed had been at the origin of the most important crisis in Europe. Both BSE and dioxin were feed-related crises. We introduced crisis management structure, a crisis cell, safeguard cell. We created emergency procedures, which we lacked. There wasn't the possibility for the EU, for the Commission at the time, to take measures overnight if that was necessary. These were introduced in the white paper program. And finally, there was the announcement of important legislative reforms, recreating the regulatory framework. The white paper was actually announcing 84 legislative measures which were needed. And these 84 measures were enacted in the following 10 years. The most important of these measures is, of course, Regulation EC number 178 of 2002, because that is the new founding of the food law in Europe. It contains the general food law, which we didn't have before, with definitions. What is a food? What is food law? What are the principles? Principles of risk analysis, for instance. And it is introducing a new coherent and comprehensive approach. Before that, all the measures which we had taken were piecemeal. Someone said, oh, we need to harmonize additives, so we had the directive on additives. And then we said, oh, what about contaminants, heavy metals and the like? We need the regulation on heavy metals. But there wasn't a comprehensive approach, and this is what Regulation 178 did bring. The basic principle behind Regulation 178/2002 is that we need traceability. It's because we didn't have traceability that the BSE crisis turned into a disaster, that the dioxin crisis turned out into a disaster, at least for Belgium and some neighboring countries. So traceability was introduced for the first time in any food law in the world in Regulation 178/2002, when we notified the draft, the proposal for 178/92, a number of countries around the world, including the US, Canada, Thailand, complained and said, traceability, what's that? This is a new invention by the EU for protectionism. I had to come to Bangkok to explain what we had in mind with traceability. I love to come to Bangkok. I don't need much pushing. But there was loads of questions in this country about what was this new traceability concept. In the meantime, everybody in the world has traceability in their legislation. It is in Codex, indeed. Traceability existed before, but not as a requirement of food law. It existed in quality control, for instance. There was an ISO standard about traceability, but it was the first time that we introduced compulsory traceability as a requirement of food law. We also introduced the principle of risk analysis as they were enshrined in Codex. That's the beauty of being able to start with a blank page when you design your food system. You can implement the basic principle, and one of them is that there should be, I'm quoting Codex here, there should be a functional separation between risk assessment and risk management. And this is why we created EFSA. EFSA, European Food Safety Authority, is independent from the Commission. Before that, the scientific committee were within the Commission, which means that the Commission had some control on what the scientific committee, on what the subject they would look at, and also, in a way, on the outcome of the scientific opinions. No more, and you will hear a lot today about EFSA, how it is organized, and how the principle of excellency and independence are at the core of the operation of EFSA. We also clarified the way we want to deal about risk management in Europe. Risk management is in the hands of the Commission, the Member States, Council and Parliament for the most important measures. Of course, risk management has to be based on the risk assessment, and that we have laid down in our legislation. So in the EU these days, risk management can only be based on the outcome of risk assessment. If that's not the case, anybody can go into a court in Europe and challenge the measure which has been ignoring risk assessment or adopted without risk assessment, if there is a risk. Of course, not everything is a matter of risk. We will see later this morning that labeling legislation, for instance, is not about risk. It's mainly about informing consumer. There may be some risk aspects, labeling for allergies, for instance. That clearly is a risk-based measure, but most of the labeling rules are not risk-based. But if what you deal with is risk, then there must be a risk assessment first. We've also introduced the precautionary principle. Precaution principle is for exceptional situations where risk assessment could not be completed, or maybe it was completed, but it was unconclusive. On the one hand, on the other hand. So you have to take measures, protective measures. But at the same time as we introduced the precautionary principle, and again, that was a very big concern in Thailand at the time, when you introduce the precautionary measures, you must have attempted a risk assessment, you must be in presence of a potential risk for human health, and the measures which you adopt as a risk manager have to be proportionate with the existing risk, cannot be discriminatory, and very importantly, have to be reviewed as soon as you can complete the risk assessment. The very reason why we don't think that the precautionary principle would be abused in Europe is that the EU itself is first and foremost a free trade area. The main purpose of the EU in the beginning was to create a free trade area amongst the 6, then 9, then 15, and now 28 countries. So if you could use the precautionary principle to disrupt trade, it's the EU which would not be functioning. The EU is also the biggest exporter in the world and the biggest importer, the biggest exporter with the US, depending on the relation between the dollar and the euro. But with the US, we are the largest exporter in the world, and we are by far the largest importer, including of agricultural products. So obviously, we have no interest in having the precautionary principle being abused. And I don't think that in the 10 years that we have had it in place in the EU, we have abused it. In line with Codex, we also provided that risk management may be based on other legitimate factors. And in the EU, as you know, we are very sensitive about issues like animal welfare, environment, privacy, and these issues. We call them other legitimate factors. And finally, transparency was an important component of the white paper program and of the Regulation 178. I would think that we were a bit secretive in the EU. We didn't consult properly. I believe that now we do. The Commission does, EFSA does. Just look at our websites, EFSA's website or a Commission website. They're not easy to find on the internet. But we have compulsory rules about consulting stakeholders before adopting a measure. If we don't consult, you go to the Court of Justice and the measure will be annulled. There's pending cases currently, both against the Commission and against EFSA, challenging the way we've adopted some measures. And finally, we extended to the food sector the rules on access to information, which were already in place in several other sectors, notably environment, for instance. The new regulation also clearly assigns responsibilities, essentially that it is the producers who are responsible for food safety and the authorities are responsible for controls. In the EU, most of the controls are in the hand of the member states. The Commission itself is not controlling on the marketplace. The member states do that. These days, most of the legislation is generated at EU level and all the controls are made at member states level. Regulation also provides for equal treatment between domestic producers and importers. This is obvious in the WTO system under SPS and TBT, but we have written it into legislation so that if anybody believes that he or she has been unfairly treated as a third country operator, you can go to any court in the EU, which is obviously much better than having to go to WTO to challenge. Only countries can go to WTO. Operators cannot. But operators can go to any court in the EU and challenge a measure, a legislation, which they believe is discriminating against importers into the EU. And finally, the white paper program and the Regulation 178 have placed a new emphasis on enforcement, on communication, and on training. And now that we are reaching the end of our program, the white paper program, this is the most important part, enforcing all these legislation, maintaining them, streamlining some of them, and I will talk about that in a minute, and also training, explaining, reaching out, and this is actually what Claudia, Gudrun, and myself are doing today. We explain our rules to third countries because these rules are complex. We keep changing them, and we rely on you, both producers and authorities in third countries, to implement these rules because we want that everything which is shipped to Europe conforms with all legislation. We are negotiating an FTA, but the golden rule is in Europe. If you want to market in Europe, you comply with the EU rules. And we know this is a challenge. This is why we are helping you in knowing what the rules are, knowing when they are changing, know what they mean, know how to implement them. And we have a number of training programs under what we call the Better Training for Safer Food program, and some of the operators of the BTSF program actually in this room. Some are based in Thailand. And we will have some of these workshops. We will have one either before the end of the year or just after on plant protection products and pesticides residues for all ASEAN countries, but we will have it here in Thailand. We will have one on animal welfare, also in Bangkok, for all ASEAN countries plus a few others, perhaps in this hotel, perhaps in this room. But you will be informed about this in due time, although these workshops are mainly meant for officials, but I can see some officials in the room. A few words about EFSA, not about the operation of EFSA, because Claudia will explain that, but just the concept behind the creation of EFSA. Actually, EFSA was created without any transfer of competence from the member states to the EU, to the Commission, to the Parliament. This is important because this is what is difficult in the EU, is take some competences away from the member states and give it to the EU. Member states, and reasonably so, always check that this is really needed, that the member states could not do better themselves, what is proposed to be transferred to a central operation in the EU. When we created EFSA, that was not the case. We took Commission competences within the Commission and transferred it to an independent authority outside of the Commission. EFSA was not meant to facilitate the operation of the internal market. And here you will see that the entire program of the white paper and Regulation 178 is quite different from what we had been doing in the 40 years before. Between 1960 and 2000, we essentially did harmonization of law for the operation of the single market, free movement of goods. From 2000, the main purpose has changed. Now it is food safety, much more than internal market. The program of read the white paper, I'm not sure that there is one reference in 80 pages to the single market or the internal market. Read Regulation 178/2002. There's no mention of operation of the single market. Food safety is the only purpose of this new regulation. A dramatic change, if you think about it, vis-à-vis the 40 years of legislation before. The management board of EFSA is composed from individuals, not member state representatives, as is the case of other agencies. And it is funded by a contribution from the EU budget. In other terms, EFSA is not receiving fees for services from the companies who make applications to EFSA. However, that was the context in which EFSA was created, in the 10 years that followed, the legislation which was foreseen in the white paper and which was passed is introducing centralized authorizations for products. The first one was the GMO regulation. The GMO regulation provides that GMOs will be authorized by the EU, by the Commission, on the basis of a scientific opinion from EFSA. And applications from companies are sent to EFSA. EFSA reviews them and then delivers an opinion to the Commission. The Commission is granting an authorization for GMOs. This is very different from the system before, where GMOs were approved by the member states. Then we had in 2006 a regulation on nutrition and health claims, very important regulation.